Name is Tibet Kara. I am the Secretary General at British Chamber of Commerce. We've got a great webinar topic today and a great company to do the presentation. Our topic is establishing and operating business in the UK. And our premium member Denton firm is going to do the presentation. And we have our vice chairman who is going to do also part of the intro and the presentation, Tamsin Milman. She's also the senior partner at Dentons. So I'm passing the word to Tamsin. Thank you. Have a great webinar.
Thank you, Tibet, and welcome, hoş geldiniz, everyone. I'm here in two capacities today. So firstly, yes, I'm the Vice Chairman of the British Chamber of Commerce. And I know all our members know we're the second oldest chamber in Turkey. We've been supporting business in Turkey since 1887. But I'm also here in my other role, which is as a partner of Dentons. We are the world's largest law firm with 160 locations in more than 80 countries. And I am actually based here in Istanbul. We also believe in long-standing relationships and creating relationships with our clients. So I have been based here since 2011, advising on international aspects of banking and project finance transactions. And my partner in Dentons Istanbul is Nadia Jansen, who I will let introduce herself in a moment. But Nadia has also been based in Istanbul for a long time, even longer than me. So we are definitely used to being here and creating relationships with our partners. We are delighted today to be joined by Chris Colclough and Ryan Chia, who we work with a lot from our UK offices. So I will also let them introduce themselves in a moment. We wanted to do this webinar today because being based here in Turkey, we see both sides of transactions that are going on. We understand how Turkish business operates and the way of doing things, but we also were trained in the UK. We are both British, so we also understand the differences between the two cultures. We've also seen in recent years a real increase in Turkish business expanding abroad, and particularly in the UK. And we were pleased last week to see that the foreign direct investment volumes in 2023 increased significantly, both in the UK and in Turkey. So we thought this was a great time to talk to you about starting and operating business in the UK. But we have also seen the other side. We're starting to see how important it is that you get the right advice at the beginning when you're looking at expanding to the UK. We have seen some structures that have been set up perhaps a little bit hastily, and that don't really work for the project that the clients wanted to enact. So we also want to touch on that a little bit. It's really important to get the right structure at the very beginning. So on that note, I'm delighted to hand over to Nadia, Chris and Ryan to introduce themselves and explain some of the available structures and issues you should think about.
Thank you, Tamsin. As Tamsin said, I am her partner here based in Istanbul. I've been in Istanbul since 2006. I was at a previous firm before I joined Dentons, so a little bit longer. But I also trained in the UK, so I'm English qualified. I advise on the international English law aspects of M&A transactions in this market. And in working and discussing these topics with Ryan and Chris, and we were talking about sort of the links between Turkey and the UK. It seemed to make sense to put together this discussion, and really the way in which we put it together is sort of the reverse of those questions that quite often we see foreign investors asking us here when they're coming into the Turkish market. To try to sort of relay that the other way. So addressing all of those sort of points in detail, and we'll come on to that. But perhaps before we kick off, I'll hand over to Chris and to Ryan to give a short intro.
Thanks, Nadia, and thanks, Tamsin, and good afternoon, everyone. I'm Chris Colclough. I'm a partner at Dentons in the UK. I've been with the firm for 17 years, and I head up our corporate and banking team in our Milton Keynes office, which I don't expect anyone to appreciate where Milton Keynes is, but it's about 50 miles north of London, sort of equidistant between sort of London, Birmingham, our two major cities in the UK, and sat right in between Oxford and Cambridge. So right in the heart of the UK. And within our team, we run the company secretarial function for Dentons UK and our clients. So any incorporations of companies within England and Wales from across the Dentons network come through my team. And we also have a roster of about 500-600 clients who use us each year for company secretarial services, and about 300 or 400 of those use us as a registered office function, which we'll sort of address later on in this talk. And I'll hand over to Ryan.
Thanks. Good afternoon, everyone. I'm Ryan Cheer. I'm a senior associate in the corporate team, also sitting in Milton Keynes. And my general practice is transactional M&A and also non-transactional corporate governance.
And Nadia, sorry, I realised I didn't mention the Q&A part. There is a Q&A button at the bottom of everybody's screen. So if you have any questions as you go through, please feel free to add them there, and we'll try to address them as we go through.
I think I'm going to give the floor primarily now to Chris and to Ryan, because before we start, we have some slides that will probably help to set the scene, because I think the Q&A that we're going to run through will sort of speak to that background, and it might be helpful just to have that in mind when listening to the discussion that's going to follow. So I'll hand over to you.
Thanks. So I think just a very little bit of sort of basic sort of background, because I appreciate it's could potentially be quite confusing, and there's many people within the UK that kind of misunderstand this. But when we talk about the United Kingdom, we're talking about England, Wales, Scotland, and Northern Ireland. So they're separate countries with separate legal systems, but they share the same company law. So what we'll be talking about today is England, Wales, Scotland, and Northern Ireland. Ireland is a completely separate legal jurisdiction and a completely different company regime. Similarly, Isle of Man, Jersey, Guernsey, the Channel Islands are separate jurisdictions and operate different company law procedures. So we won't be touching on those. So that helped understand where we're talking about. Ryan and I are English qualified, so we can talk about the laws of England and Wales. Scottish and Northern Ireland company laws the same, but a lot of their other laws are very different. So real estate in Scotland is completely different to real estate law in England and Wales, for example. But what we can give you an overview is company law as it applies to England, Wales, Scotland, and Northern Ireland. And we're going to be talking about limited companies and why they're used predominantly, for a lot of activities in the UK, but also for sort of external investment and operation in the UK. And one of those reasons is by creating a company in the UK, you create a separate legal entity. It has its own personality, and it's completely separate from its directors who run the company and its members who own the company, and it can exercise its own rights and powers subject to its constitution. And it's able to own its own assets. It can own real estate, it can enter into contracts, and it can sue, and it can be sued itself. Next slide, please. And then the importance of it being a separate entity is also to ring fence its assets and liabilities from its parent or its shareholders. So a shareholder in a company has a limited liability to that company, simply to pay any unpaid proportion of its share capital. So if subscribed for shares, it can only ever be called upon to pay for the balance that's due on those shares. It has no other sort of liabilities to the company, no obligation to fund it going forwards. One caveat is that that's the sort of the legal position between the shareholder and the company itself. If you're a third party contracting with a company in the UK and that company has no credit worthiness or sort of financial sort of history, then it's not uncommon, as is the case globally, for that third party to require a guarantee from another group company which has appropriate sort of financial support. So parent company guarantees, for example, could be required, typically for finance transactions, also for real estate leasing arrangements, etc. So the commercial sort of reality sometimes overrides the sort of legal sort of position. Next slide, please.
So everyone may be familiar with the concept, or you might have heard of directors and members. They are very distinct in terms of how they engage with it from a company law perspective. So the directors are those individuals who run the day-to-day operational management of the company. They'll make decisions on behalf of the company, and they have the ability to actually bind the company. So liaising with third parties, they can confirm and commit the company to enter into arrangements. They don't have any personal benefit from the profits of the company, and it's possible that the directors can also be shareholders, and in which case they may do. But in terms of strictly, directors are not meant to have a personal benefit. They're meant to be independent, and they have certain duties, which we'll come on to speak to on the next slide, to act in the best interests of the company for the benefit of its members as a whole. They're not meant to be making any decisions which are for its own personal benefit. And when they make any decisions as a board of directors, typically the directors' votes are done on a per director basis without any reference to how many shares they own. So that's directors. And then separately, we have members, or you may have heard of them called as shareholders. So those are the people who own, have ownership, economic ownership in the company. They own shares and therefore have voting rights which are pinned to their shares. They may be entitled to receive dividends based on the profits, and they have certain rights which attach to their shares. Typically, because the directors deal with the kind of operational management, day-to-day decisions, the shareholders will typically deal with perhaps more high-level and strategic matters. And they do not have any authority to bind the company themselves. It's only the directors who can do that. But there are no duties that the members or shareholders owe to the company. That's purely for the directors. And I think I think the other major point, I guess, is in terms of, as Chris has said, the limited liability. The point is that only applies for shareholders. Directors do not have limited liability. As mentioned, there are certain duties which directors automatically have. And for the large part, they are codified under the Companies Act, so statutory duties. Oh, I think they're coming through now. Yes, thank you. So as you can see, there are 7 core duties which are automatically binding on all directors under the Companies Act. So the duty to act within the company's powers, i.e. per its constitutional documents, the duty to promote the success of the company for the benefit of all of its members, not just for any one, the duty to exercise independent judgment, so not to be biased by any other factors, and to exercise reasonable care, skill, and diligence whenever they're making any kind of decision. And that's based on both an objective criteria as to what a reasonable director should be able to do, and also a subjective standard based on what the actual director has. So if the director has particular expertise in a particular area, then a kind of greater threshold would be applied there for that requirement. And then on the bottom, you can see there's a duty to avoid any kind of conflicts of interest, which might apply if the director has any other responsibilities or duties to any other entity. They cannot accept benefits from any third parties as part of their actions as a director, and they must declare any kind of interest in any proposed transaction or arrangement with the company. There are other common law duties, and they might arise in certain scenarios, such as insolvency. But for the large part, these are the main duties that you should be aware of. And then next slide, please, Tamsin.
Thank you. And we'll sort of refer to Companies House quite a lot during this presentation. And Companies House is established by the UK government. It's a government body. It's created in 1844, and it is the official registrar of companies in England, Wales, Scotland, and Northern Ireland. And its purpose is to incorporate, maintain, monitor, and dissolve, strike off companies in the UK. It's going through quite an overhaul at the moment. By their own admission, some legislation that came into force in March this year. It's the sort of the biggest shake-up of Companies House in its 180-year history. It's been given additional powers and responsibilities with the premise of helping to fight economic crime and to improve corporate transparency, but it's placed a number of responsibilities on Companies House, which historically was a very passive organization. It kind of received information. It never really sought to verify the accuracy of the information. As long as boxes were ticked in the appropriate places and forms were completed, on the face of it, completed, they would have to accept it, and it would be sort of stored on their records. Now they have they're now an active gatekeeper of the information at Companies House, so they have to check the veracity of the information that's provided to them. They have much greater powers now to ask questions, to challenge, and they can refuse applications much more readily now, just with the goal of ensuring that the information which is going to be stored at Companies House going forwards is accurate and complete. So I think that's the sort of, hopefully, a helpful summary of some of sort of the basics of UK company law and some of the concepts we're going to be talking about as we address the questions. And please, that's the end of our PowerPoint presentation.
Okay, great. So I think just one thing that occurred to me while I was listening to that introduction, perhaps to make clear, is that unlike in Turkey we have the Turkish Commercial Code. In the UK we have there's the Companies Act, or there have been a series of Companies Acts, and alongside that there is also the body of case law, because we come from a common law system. So even when we're talking about relatively, I would say, basic corporate concepts, such as Ryan explained around the director's duties point, and this speaks to why getting the right advice is important, because it's not just what's written in the Companies Act, which we can access online fairly easily, but it's also to have this broader understanding that there is also this common law system that sits behind it, and not everything that is in the Companies Act represents the entirety of the picture. So you need to bear that in mind as well. So in terms of when we're coming to set up in the UK, what sorts of entities can be established? In Turkey we have primarily joint stock companies and limited liability companies, but how does it work in the UK?
So in the UK, we can also you can trade as an individual, or you can trade as a corporate entity. So individuals can trade as sole traders, or if they combine with 2 or more people, they can form what's known as a partnership. They are not typically as popular anymore, because it means that when trading, you're doing so in your personal names, and therefore it means the liability is assumed as in their name and their assets are at risk. What is much more common in modern times is for businesses to be run through a private company. And in the context of overseas investors wanting to move into the UK, that private company would effectively become a wholly owned subsidiary of the overseas wider group. So private companies are very flexible, particularly in that ownership structure, how you set them up. as we mentioned in the slides earlier on, they have the benefit of limited liability, so they don't pose any risk to the shareholders sitting behind it, or within a group context, it doesn't pose a risk to the wider group assets. It's completely ring-fenced. And they are also beneficial because they can, like I said in the slides, they can enter into their own contracts, own their own assets, raise finance on their own merits, and they are taxed as a corporate entity, which is different from a sole trader or a partnership.
So what would you say are the sort of the considerations if you're trying to decide what type of entity to establish? What were the key considerations that you would suggest people take into account?
Well, I think the main kind of drivers are the ring fencing of the liabilities, and tax typically is also, again, a main driver. Then I think you'd have to take into regard kind of the day-to-day kind of pros and cons, the ongoing kind of administrative requirements that go with the structure you choose, and the flexibility you have in terms of how you want to liaise with other shareholders, or if you have envisaged any kind of a future exit. Companies in particular are in a well-trodden path to sell a business, and it's and it also helps from a public perception, particularly in the UK. Companies are, you know, are the main form of corporate entity that businesses use. They are, you know, recognised, and everyone's happy and comfortable with how they operate. And so, I think if you choose one of the more less common structures, then you're kind of fighting against that, and you're having to kind of get people. It may make life a bit more difficult, I guess.
And then in terms of the registration process, I mean, we've experienced it here, you know, with dealing with the trade. We have the trade registry concept, which is, I suppose, it's not really the equivalent of Companies House, but it's how we go about registering here. And there are different trade registries in different areas. So how does the process work with Companies House? Is that purely, we're moving to a massive sort of online system here, but it's not as fully automated in the way that Companies House is. How does that work? Sort of generally in terms of incorporation, and then what you need to do once you've got your company up and running.
Yeah, so at the moment, sort of Companies House is sort of a dual track sort of system. So you can still incorporate through a good old fashioned paper form posted to Cardiff, which is where the main office of Companies House is, or in a smaller office in London, or you can sort of turn up on spec and get that sort of done. But predominantly a lot of incorporations are now done electronically. We have software which provides company secretary services, and that sort of now links into Companies House, so we can incorporate electronically, and as long as you've got all of the right information, you can incorporate extremely quickly. It's always within the working day, potentially sort of the same business day. I'm not going to sort of throw that out as a sort of guaranteed service, because it does necessitate having the right information, and that the information requirements are becoming increasingly more complicated. Certainly, the sort of records of people with significant control, so like the sort of ultimate beneficial ownership, is quite complex. And as I sort of mentioned at the start, we're sort of in a transition period with Companies House and corporate transparency, and some new legislation that came in force earlier this year has set a path for requiring directors and people with significant control to have their identification verified. So that's not in force yet. There's going to be regulations setting out how that's going to work in practice, but that's going to, improve transparency within the UK, but it's inevitably going to sort of create more red tape and bureaucracy and slow down the opening of new matters, and also to ensure that the Companies House can sort of maintain the quality of information that's provided to it. It will also be limiting the number of people who can submit information to Companies House.
Right.
So you will either need to be an officer or an employee of the company in question, and have had your ID verified. or you would need to go through an authorised corporate services provider, which would typically be a UK law firm, accountancy practice, who's kind of set up for kind of money laundering processes. So they're kind of familiar with the sort of the ID verification processes in the UK. So that, again, something that's going to come into force. So what historically was extremely simple, and, you know, I was dealing internationally quite regularly with clients setting up UK companies, they were amazed that you can just, you know, just give me this information, I'll get you a company set up, you know, later today. It's, looking back, it's probably a little bit sort of too simple, and, you know, it's led to issues with understanding who owns and who has interests in UK entities, and has been abused. So we're sort of going the other way now and having a bit more bureaucracy. So it's going to slow down the process a little bit, and inevitably there's going to be sort of teething problems as companies now starts to implement new sort of new rules.
And then, so Companies House is sort of the has the overreach over the entirety of England, Wales, Northern Ireland, Scotland, you said. So in Turkey, there are certain regions where it might be advisable to these free trade zones, where it may be there are slightly different rules around incorporation, and there might be incentives and tax benefits to being established in a particular location. Is there something equivalent to that in the UK, or is it all basically it's one region and you don't have...
Yeah, so we don't have sort of free trade zones in the UK. It's just kind of a sort of blanket sort of equality sort of across the UK. There are places extremely close to the UK, so the Isle of Man, the Channel Islands, where there are sort of favourable sort of tax treatments, and we do see people setting up businesses there, but the administrative costs of doing so can be quite high, plus also they're not physically based in the UK, so that's a very tax driven sort of rationale for setting up in those jurisdictions.
So in terms of establishment then, what are sort of the minimum requirements in terms of capital, registered office, number of board members, all those things that, you know, in any country you have to pay credence to when setting something up from scratch?
So again, very simple. So you just need one share to incorporate a company. So it could be a penny share. Typically, it's £1 or £100 sterling. You can also have your shareholding in other denominations. So quite often see euros being used if that's the accounting sort of currency that the group is using. If you were to set up a public limited company, which is sort of slightly different to a private limited company, that has a minimum requirement of a share capital of £50,000, but only 25% of that needs to have been paid up to incorporate. So for £12,500, you can set up a PLC in the UK. The money itself doesn't need to be paid up on incorporation for a private company, so it can be left outstanding. And as I sort of mentioned at the outset, the only liability of a shareholder is the amount unpaid on its share capital. So if it subscribed for 100 shares and it hadn't paid that, it could be asked for that by the company, or if it went into liquidation, a liquidator would come and ask for their £100. It can also affect the voting rights if it's unpaid. So it's usually sort of prudent to pay that money. It's usually typically paid into the company's bank account once it's opened, or into a group account if there is one. And then sort of talk about registered officers. So every company has to have a registered office address. It doesn't need to have a physical place that it operates or it trades. So it doesn't need to have its own sort of UK presence, but it does need to have an address at which third parties can communicate and, you know, from a legal perspective, serve legal notices, start court proceedings, etc., at that registered office. And this is an area which has sort of been tightened up again under changes to UK company law. PO boxes aren't allowed. It has to be what's considered an appropriate address, and that means somewhere where post will be received and will be kind of forwarded on to the decision makers of the company. And the Companies House have already sort of said that this will be one of the first things that they'll be sort of having a drive to prevent the abuse of registered office addresses. So I think it's quite often used for sort of fraudulent companies and so forth. So there's going to be a real focus on that. As a company secretarial team, we have our offices in London, Milton Keynes, Edinburgh, and Glasgow, which many of our clients use as a registered office address. And we have a service where we receive the post, scan it to clients, and that avoids them having to sort of set up an arrangement with another company or to sort of acquire a property within the UK.
Okay. And then what about board requirements in terms of, board composition is important, and the question that we often get asked by foreign investors coming here is, can foreign nationals be directors of companies in Turkey? Do they need a tax ID? Do they need to be resident? How does that work then in the reverse if you're going into the UK? Do you need to be British and have a tax number and et cetera, et cetera?
Yep. So in terms of default positions, in terms of there has to be a minimum of at least one director at all times. If you're a public company, that is 2 directors minimum. And within those minimums, you have to have at least one natural, a human being as the actual director. There's going to be some tighter regulations coming in as to how corporate directors can be used. And there's some kind of conditionality that at least the corporate director has behind it, its veil, a natural person sitting behind it. But in terms of overseas investors, there's no requirement for a director to be British or for there to be a minimum of one British citizen. And they don't have to be domiciled in England either, or the UK. They can be overseas.
Okay. So it's a bit in the rules here. There's some requirements a little bit different here, but it sounds like it's quite subject to the new changes that are coming in. It's relatively straightforward from an administrative point of view for a foreign individual to become a director. You touched upon in the slides then the main corporate bodies of the company being the shareholders and board of directors. So in terms of how they operate, what are the rules around requirements for holding shareholder meetings and the requirements for holding board meetings? Are there minimum annual requirements that have to be met, and how do you go about monitoring that?
So for private companies, for private companies, there's no longer any requirement to hold AGMs. Public companies still need to do so, but that's why private companies are so popular, because they're so flexible, and effectively the decision-making structures can be designed to however the shareholders want them to be. In terms of the Companies Act, it allows for a company to make decisions, for the shareholders to make decisions both in a meeting or by resolution in writing. Bar a couple of very remote exceptions, pretty much all decisions can be done in writing, and that tends to be the more modern way, I think, going forward because of the ease of it.
And no requirement to have any government official attend any of those shareholder meetings?
No, not at all. You don't need any notaries. We don't have that kind of concept in the UK in terms of connected to companies. And in terms of shareholder meetings as well, because of the modern age, they can be done virtually. You don't have to do them in person. So if you're an overseas investor, you don't have to travel across to the UK for every meeting. You can do that by just logging on virtually.
Test around where the meetings are physically held, not being in the UK. Okay. And then what about the decision-making process? Is it similar to how it is here? Certain decisions require a certain threshold of votes for resolutions to be passed?
Yes, so there are the Companies Act does stipulate certain decisions need shareholder resolution and approval, but they are quite limited. So typically you would find within a commercial context, the articles or shareholders agreement would stipulate which decisions need consent.
Yeah.
When it comes to decision making from a shareholder perspective, there's two kind of thresholds. There's an ordinary resolution, which requires more than 50%,
Yeah.
and then you have a special resolution, which requires at least 75%.
Okay.
Those two types of resolutions can be passed, or they can be voted upon, whether by show of hands, where everyone just has one vote, or on a poll where everyone's you have one vote per share effectively, and then you'd have weighted voting depending on how many shares you own.
Yeah. And then what about directors' board meetings? Are there rules and requirements around how often they need to happen?
No, again, there's no kind of statutory minimum of how often the board needs to meet, but given they actually run the operational day-to-day business, it tends to be more regular than shareholder meetings. But the articles for each company will stipulate the kind of minimum notice periods which should be given to all of the directors. That is more so a protection to make sure that every director has the ability to join a meeting and isn't kind of left out. But all things being good, there's no reason why directors can't agree to waive that notice period and to if an urgent matter comes up, for them to be able to jump onto a call or to decide things over a text message or a set of emails.
Okay, great. So then in terms of ongoing requirements and operating the business, as things move forward, are there certain sort of minimal amounts of information? I mean, Chris spoke to the new requirements that are coming in around transparency and details of UBOs, but on an annual basis, and in terms of decisions that the entity might make during the financial year, are there certain things that have to be filed with, like, Companies House, like we have to file here with the trade registry, for example?
Yeah, so there are certain sort of annual filings. There's a confirmation statement which essentially sort of confirms a lot of the sort of basic information that's held by Companies House, and that's filed once a year. That would be an opportunity to update on any changes to shareholdings, for example. And then annual accounts need to be filed at Companies House, and the sort of complexity of those accounts depends on the size of the company, and then accountants would sort of advise to whether it needs to be sort of short form, simple accounts, which small companies can provide, or whether it would need to be full audited accounts. And even dormant companies provide a very basic dormant company accounts. So that's the sort of the sort of annual requirements, and then everything else is event driven. So changes to directors, issuing new shares, if you change your registered office, change your articles, constantly, there's statutory obligations to update the information, typically within 15 days of things happening. So that's sort of the usual sort of day-to-day
ongoing requirements. And then in terms of how that's managed, I mean, there used to be a role, I mean, I had this role when I worked in house of being the company secretary, and that responsibility typically fell on me to make all the filings, and that was in the context of a listed PLC, so it was a bit more involved perhaps than it would be in a private company. But is that something that the companies themselves can handle, or does that need to be outsourced at all?
So that there is a sort of a legal role. So an officer of a company, so you have the sort of directors, but there is also a position as a sort of company secretary. And for public limited companies, they still need to have a company secretary. But the changes to the company legislation that came in, it's the 2006 Act, but they sort of came in the years following that, sort of relaxed some of the admin associated with private companies, and it did away with the obligation to have a company secretary. So a private company doesn't need to have someone in that official role, but it obviously does need to perform the functions of a company secretary and make sure it complies with its obligations to maintain statutory records, so registers of members, directors, persons of significant control. There's going to be some changes as to those registers, but there will still be continuing obligations for the company secretary to maintain certain registers. Also, someone within the business to make the filings. So if you don't have someone who does that, then usually falls upon the directors. And our experience is that it's kind of a moving landscape. The forms change year on year, and if you're sort of just managing one or two companies, then it can be quite an effort to sort of make those filings. Whereas if you use a professional provider, like ourselves, who are doing them sort of day in, day out, then it's quite simple for us to do that. So yeah, we provide a company we're not often not named as a company secretary, but we provide that company secretarial service for a lot of clients across the globe.
And then what about, just to hear, the bookkeeping is something that I just want to explore the differences there. So you say about maintaining the register of members, register of directors. Do you have to keep hard copies of all of those and hard copies of minutes in some official books, or is it a bit more fluid?
So we do. I mean, we've got some very old companies, and we have some very dusty books that we do maintain for our clients. But typically, everything's done electronically now. So we have a sort of company secretary software which allows us to maintain everything electronically. It makes it easy to update it, to share that information. So that is quite okay to sort of store that electronically. Minute books are sort of slightly different, and they should be kept sort of under a sort of separate duty. But again, typically sort of they're stored electronically by the company.
Okay. And then in terms of one thing that it's always a discussion, I guess, in pretty much every M&A transaction, wherever you do it, especially when you're talking about a situation where you've got new shareholders coming together, and you have a shareholders agreement that sits alongside the constitutional documents, as to, first of all, like, what does the shareholders agreement itself have to be filed publicly, and if not, are there any rules or guidance around the extent to which certain provisions in that shareholders agreement need to be reflected into the articles of association, and are they available publicly in their entirety? So how does that work? Because I think shareholders agreements, if we're getting into more sophisticated arrangements, they can be quite sensitive.
Mm-hmm.
And it's a question that I always get asked about how it works here. So what's the deal in the UK on that?
Yeah, so I mean, you're correct. It's essentially a private contract between the shareholders, and there's no obligation in principle for those for a shareholders agreement to be filed at Companies House. The only exception would be if the articles are prepared in such a way which refer to the shareholders agreement, and you cannot understand the relevant provisions in the articles without seeing sight of the shareholders agreement. So the lawyers would typically be very careful to make sure that the articles are drafted in such a way so not to trigger the shareholders agreement to be required to be filed.
Yeah.
But typically the articles and the shareholders agreement will be considered together when drafting, and there would be kind of overlaps between some of the issues that they go into. There would be it's always advisable to have at minimum within the article certain protections. And that is because within the articles, because it's the constitutional documents, it would allow upon a breach for a claim to be made under the under company law, as opposed to just being a breach of a contract, which requires just a contractual remedy. So and also because the constitutional document is technically a contract between the company and each shareholder, you have a claim against the company directly, as opposed to under the shareholder agreement, which just typically would be a claim against another shareholder.
Okay. And is the entirety of the articles of association available publicly at Companies House?
Yes, there's an obligation for the directors to make sure that the articles are maintained and up to date, filed at Companies House.
So if you're an inbound investor, if you're an investor and you're checking out the potential target, are you able to just access that online and obtain it, or do you have to be registered to be able to get hold of it?
No, anyone can access it. There's, I don't think there's any restrictions from, from overseas people accessing the Companies House register. And I think that's widely available. But obviously, the only caveat is that this assumes that the company has been diligent and updating the Companies House when they should have.
Yes.
So,
Which is why you need to get someone to do it if you.
yeah, exactly. As part of our diligence, when we're doing any kind of transactional work, we would sort of verify to make sure that the most up-to-date version of the articles is as we expect.
Okay. I know I'm just conscious of time, and we've got a few other points that we want to cover, but there's just a question in the chat, and I wondered if we might be able to touch on those. I don't know if either of you can see those. So the first one about, does the UK Companies House have ordered new companies in the UK to have an OCBA?
So I'm not familiar with the OCBA.
OCBA, I'm not sure. I don't know if the person who sent that could clarify what they mean by that. But there's a subsequent question. Does the minimum paid up capital amount change if a foreigner joins the board and is resident in the UK?
No, so they're the same, whatever the sort of shareholder base or the directors.
Yeah, it's parity of treatment, right? Completely.
Yeah.
For nationals, offshore corporate bank accounts. Sorry. So the UK companies, they ordered new companies to have an offshore corporate bank account.
So is it sort of, sorry, I'm not sure if the question is, does Companies House sort of compel people to? There's no obligation to have a bank account for a company. So quite often you've got sort of group structure where you've got intermediate holding companies that don't operate, they're just there within a group, then they typically don't hold a bank account themselves, and they would rely on another group company to hold any funds that flow through them, and it's more of an internal sort of accounting sort of basis.
Sometimes you find that banks are quite reliant on what's at Companies House. So if you're trying to open a bank account, they might say, well, we've looked at Companies House, this is who the directors are. Yeah. If you're telling us it's otherwise and then you're a director and you're not listed, update Companies House, and then we'll take that box off. So
okay. And then in terms of, you touched upon the difference between sort of what rights lie in respect of claims against the company or claims between shareholders. But if we sort of dial back a bit and we look at, what happens, so you've set your company up, you may be in partnership in a joint venture arrangement with other shareholders. And, I think Tams and I have both seen this situation arise where there are English law governed agreements where perhaps the rights are not clearly defined. And perhaps, again, this could come from things were done in haste or not with perhaps an awareness of what's in the Companies Act and what is not, and it's therefore a matter of common law. So if you don't have a shareholders agreement that sets out who's got the right to do what, and what protection does the Companies Act offer, if any, to shareholders, and particularly those who hold a sort of a minority interest in the business?
So yeah, in the absence of a shareholders agreement, then the parties would effectively fall back on their rights under the Articles of Association and under the Companies Act. Obviously, the articles would be bespoke to each company, so they can stipulate what they want. But under the Companies Act, the rights and protections are quite limited, and the rights are quite generic as well. So, in terms of from a shareholder's perspective, they only really have rights to have access to the company's registers, just to verify that their interest is actually correct and it's been registered, to receive notice for general meetings, and to receive a copy of the annual accounts every year. they also have the right, if they hold at least 5% of the share capital, then they can also effectively demand a circular of a resolution or a general meeting to be convened. But otherwise, there's very limited rights for a shareholder. Everything else would then kind of fall onto the directors and who controls the directors. And based on purely voting control, a majority shareholder would have the ability to effectively control the board because they can then appoint more directors and then swing the vote their way effectively.
Yeah.
In the event of a deadlock where you have perhaps a 50-50 scenario, or you don't have a controlling entity, then if the shareholders do not agree on anything and on a particular matter, then you can get deadlock, and that can stifle the business. It can prevent them making the decision they need to make. Typically, shareholders' agreements will identify any kind of risk for a deadlock and then would provide for an agreed mechanism to resolve deadlock, whether that's to go to an arbitrator or third party, or for the parties to be able to buy each other out, just so that the business can continue. But you wouldn't have that right without a shareholders' agreement.
Yeah, so it comes back to the point that you if you're getting into those types of arrangements, which sort of come down the line after you've made your initial foray into the UK market, you need to have a proper contract with the shareholders to create those types of protections. And then what about if, assuming that's not in place or it doesn't function correctly, is there any protection offered to a minority at law or under the Companies Act itself if that minority shareholder believes that its rights are being adversely impacted by actions that are being taken by the other shareholders or by the majority shareholder in particular?
Yeah, so if it's the case that the company has just failed to honour the shareholders' rights, so for instance, if the shareholder holds a class of share which is entitled to dividends or to a certain benefit and it's not given, then the shareholder would then have a claim against the company. But otherwise, if it's the case that there's a majority shareholder which is abusing its position, then there is the potential for the minority shareholder to bring an unfair prejudice claim. Kind of examples of how that might be would be, for instance, if the majority shareholder excludes them from management, terminates their office as a director, issues dividends just to the majority shareholders or special bonuses, issues more shares to dilute the minority shareholder so that their percentage is reduced. So those are kind of things which would potentially give rise to an unfair prejudice claim.
And there's case law on it, right? But it's quite hard to prove that in practice.
Yes, it is. You've got to prove both that the actions have been both prejudicial and unfair.
Yeah.
So it's not so easy, and the process can be quite costly and long-winded. And even if you do have a claim with merit, you have to, incur that cost up front and then try to seek to recover that afterwards.
And I think that takes us back to even if at the outset it's probably worth perhaps investing a little bit more at the beginning of the process and having a shareholders agreement than skipping that and then it being in a situation where, as you say, you have to go down sort of a litigious or a contentious route and incur the additional costs around a formal sort of dispute process.
Exactly. It gives you all that kind of extra protection and potential to get injunctive proceedings as well if you have, remedies within the articles or under a shareholders agreement.
Okay. Great. I think that's covered everything that we wanted to sort of address in terms of overview. I think we've got answered a couple of questions that came up in the chat, but I think that kind of concludes our discussion for now. I don't know. I'll hand back to Tibet, perhaps Tamsin, to wrap up.
Yeah, I think just to touch on the questions that come through, there's a few questions on opening bank accounts.
Yeah.
Which we also see as a reverse question when people are coming to Turkey. So it's often something that comes across our desk. I think this is not really a legal question, but the KYC process is quite difficult. I mean, both in Turkey and in the UK. So it comes down to the local bank and how they can help you. There are, of course, some banks that are operating both in Turkey and the UK. I know Tibet, I think some of them are members of the chamber. And so as the chamber, we can probably help to put you in touch with them.
That's right.
But it's not something that we would probably deal with as a law firm, but certainly we can perhaps do a follow-up session on how the banks are operating. I know that it is difficult if you are not resident in the UK to open a bank account, but if you have a company, there should be some way to get that done. There is.
So Tamsin, I'd sort of echo that really, that if you have a Turkish bank and they have a UK branch, then that's usually the path of least resistance to get an account open for a subsidiary. You know, there are some banks included in the UK, including some sort of fairly mainstream banks who just aren't interested in taking on new business from newly incorporated companies with overseas shareholders. They have no appetite for that, and there's sort of money laundering sort of process that goes with that, so they're simply not open for business. But yeah, the first book I always say is, you know, speak to your local banks and see if they've got sometimes they have their own bank, or sometimes they have an associate bank that they can sort of help get you in. I'm not gonna sort of tell any, like, it's very tough, time consuming, and it's quite stressful. So no, it's it is one of the sort of hardest parts of starting to operate in the UK.
Thank you. It was a great presentation. I also learned a lot. Thank you all of our speakers. As I mentioned at the beginning, this session is recorded and the presentation will be uploaded on our website, so you can re-watch it. Thank you all for the great presentation and the webinar. Thank you all the participants for attending. Have a great day.
Thank you.
Thank
Thanks
you.
everyone.
Thanks, everyone.
Right.